Well, hello and welcome to Professional Educators of Tennessee. We're doing a quick little video webinar on legal issues with teachers. And I am Carol Lee Biggs. I'm going to be your host today. I'm with Professional Educators Tennessee as the Director of Professional Learning. And one of the advantages of being a member of PET, and this was something I discovered when I was still active in the classroom, was that we have our own attorney on staff. We do not contract with an outside firm. We have our own staff attorney, which means that teachers have legal representation available to them. As soon as you lift up your phone or do an email, you can get in contact with our attorney, who often answers within less than 24 hours. And so we're really lucky today that we have Mr. Mike Shepard, who's a pet attorney, who is going to be with us talking about some new legislation that passed in the last session on preferred pronouns and names. And so, Mike, welcome to our Law Talk today.
Thank you so much. I'm happy to be here and talk about the most recent law that became effective on May 9th, 2025.
A lot of teachers, it's the beginning of the year, and we probably haven't had a lot of time to actually read the law. And I'm not sure how many districts have actually pushed out any training onto it. So could you give us a bit of a rundown on what this law says?
Well, the law specifically says, and it's very clear, that a student, teacher, employee, or contractor of a public school or LEA is not required to use the preferred name or pronoun of a student.
Okay, so if we have a student that says they want to be called something and we choose not to call them that, are teachers civilly liable for using the I guess the name or the pronoun that's tied to their biological sex?
No, the statute specifically states that the student, teacher, employee, or contractor or the LEA itself is not civilly liable for using the legal name or a derivative thereof of a student, teacher, employee, or contractor of a public school when addressing or referring to the student. And that applies to the teacher and employee as well. So it applies to everyone. It's the same situation with a pronoun that is consistent with the sex of the student, the teacher, employee, or contractor, even if the pronoun is not the individual's preferred pronoun. So there is no civil liability for using the legal name and the pronoun that is consistent with the biological sex of the student.
Okay, so basically this means that if a student wants to be called something else, we as teachers can call them basically what's tied to their birth certificate, correct?
Yes,
Okay.
exactly.
All right. I did notice when I was reading through the law that this is something that I'm thinking might come up, is say a parent, writes a note and says that my child wants to be called this, even though the birth certificate says that. What happens if a teacher is uncomfortable with that and doesn't want to call them by this name or pronoun?
Our interpretation of the law is that you cannot have inconsistencies in the law, and it's very clear that a teacher cannot be forced to use a preferred name or pronoun, and that stems from constitutional freedoms. That's where this statute came from, and that means that teachers do not forfeit their constitutional First Amendment freedoms when they come into the school. That is, maintain that students, teachers, employees, their free speech is protected, and they cannot be forced to use language and names that they do not agree with.
So Mike, a question I have, so if the law's not being followed, what are some of the consequences?
Well, first of all, the teacher can file a complaint with the director of schools or the director of the charter school for the LEA and alleging a violation of this law. And that has to be done within 10 days from the date of the alleged violation. So there is an important date to be aware of. So I ask everyone to just be aware that it is not something you can take a lot of time with. You would have to submit uh, your documented complaint to the director within 10 days. Upon receipt of the complaint of the alleged violation, the director requires the public school to remedy that violation within 30 days from the date on which the complaint was filed. We also have a private cause of action against the LEA for injunctive relief, which is relief to where a court looks at the equity of the situation and dictates what can be done. And in this case, it would be asking the court to issue an order stating that the teacher does not have to use the requested or preferred pronoun or name. But there are monetary damages available and other relief available under the law. So those are the remedies if this is not followed properly by the district.
If a teacher is in a situation where they feel that maybe the law isn't being followed or they're being pressured to do something that they're uncomfortable with, or maybe they don't think is legal, what's the very first thing they should do?
Call us. If there is a problem, we need to know what the problem is. Interpretation of the law is subject to just that, various interpretations, but we are very confident that the student or the teacher has rights that are affirmed in this statute, and they are very strong federal rights and freedoms and constitutional requirements.
Great advice. I think it'd be handy for all PEP members to make sure that they have the website bookmarked and quite possibly have your phone number in their phone, because you never know, do you? It's nice to know that we have that ability.
Well, let me give you the phone number while we're hitting in this spot. You can call 615-778-0803, extension 103, and that will get you to the legal department and Mike Shepard.
Awesome. Thank you so much, Mike. And teachers, keep that number handy. You never know. We all like to think everything's going to go great every year, but things happen sometimes outside of our control. So thank you again for tuning in. If you liked what you saw, please continue to like the video, and I think we're going to be subscribing here shortly. And thank you so much. This is Carolee Biggs with Professional Educators of Tennessee. Thanks, Mike. Bye-bye.